Welcome back to the courtroom, folks, and buckle up, because today's case takes a shocking turn. James Frank, standing before the 53rd Circuit Court, isn't just facing one domestic violence charge. This is his third. What starts as a routine plea deal quickly spirals into a brutal reality check from a judge who's had enough. Keep your eyes on this one, because what happens next sends a clear message about accountability, addiction, and the limits of second chances.
On behalf of Mr. Frank, who's standing to my right.
Good afternoon, and this case is scheduled for jury selection and trial this coming Thursday. Talked with counsel yesterday, and counsel indicated there might perhaps be a plea-based resolution today. Do we have a plea agreement, counsel?
Yes, we do.
We also have an amended and then a count one.
And signed misdemeanor vice versa.
Mr. Gilbert, do you consent to the filing of an amended information?
I do have a copy in front of my client and myself, and we do consent.
And do you and your client waive the reading?
We do waive the reading.
All right, Mr. Frank, the agreement is for a misdemeanor plea here to an amended count one domestic violence second offense. All right, so do you understand did you read and understand the rights listed on the misdemeanor advice of rights form?
Yes, Your Honor.
And did you sign that form today?
No, yesterday, sir.
Okay. Do you have any questions for me or Mr. Gilbert about any of those rights?
No, Your Honor.
Do you understand that if you plead guilty, you will not have a trial and you'll give up all those rights that are listed?
Yes, Your Honor.
And is that what you're choosing to do today?
Yes, Your Honor.
Okay, the plea agreement provides in exchange for your plea to the amended charge of domestic violence second offense. The prosecutor will dismiss the original charge, which was the felony DV third. And there is a sentence agreement for 1 year in the county jail. Do you understand the terms of that plea agreement?
Yes, Your Honor.
Mr. Gilbert, is that a full, fair, and accurate statement of his terms?
It is, Your Honor. Thank you.
Ms. Goodrich?
Yes.
Mr. Frank, has anybody promised you anything else?
No, Your Honor.
Has anybody threatened you?
No, Your Honor.
Is it your own free choice to enter that plea?
Yes, Your Honor.
Knowing all this, how do you wish to plead to the charge of domestic violence second offense?
Guilty.
Mr. Gilbert, would you assist with a factual basis?
I'd be happy to. Sir, can you state your name for the record?
Frank.
And in May of this last year, were you in Sheboygan County?
Yes.
Were you at a residence with your significant other, I believe fiance?
Yes, Your Honor.
And that's Miss Yates?
Yes, Your Honor.
And at some point in time, did you'd consumed quite a bit of alcohol, I believe. Is that correct?
Yes.
And did you end up in an altercation with her?
Yes.
At which time you physically put hands on her and were wrestling with her? Is that true?
Yes. Yes.
And she didn't want to be touched in that manner or treated in that manner?
Yes.
And you agree that was without her consent?
Yes.
And again, that happened in Sheboygan County?
Yes.
And you have been in a dating relationship and a living relationship with Miss Yates?
Yes.
I have no further questions, Your Honor. Thank you.
And Mr. Frank, before that incident, did you have a previous conviction for domestic violence?
Yes, Your Honor.
Okay. Mr. Gilbert, you satisfied with the factual basis?
I am. Thank you.
Ms. Goodrich?
Yes.
All right. Well, Mr. Frank, I find that your plea is knowingly, understandingly, and voluntarily made, and that there is a sufficient basis in fact and law to believe that you're guilty of the offense that you pled to. So I'll accept your plea. Ms. Goodrich, do the people consent to immediate sentencing?
Yes.
Mr. Gilbert?
Yeah, we also consent.
Okay. Anything you want to say on your client's behalf?
Yes, Your Honor. I did express that I would look up the jail credit for the court, and Ms. Goodrich, I believe our number is 142. That does take in consideration the amount that he did not get credit for since his sentencing in district court. And I'd also, and we agree with the 1 year for immediate sentencing. We'd ask the court possibly consider allowing Mr. Frank to participate in the programs such as trustee or the GED program, or also I believe there's a CPT program. If the court would be interested in allowing him to participate in those, he would like to participate. Thank you.
All right, thank you. Mr. Frank, it's not required that you would say anything today, but it's certainly allowed. Is there anything you want to tell me?
Yes, Your Honor. I'm very sorry for what I've done. I know it's outside of my character to be like that, especially sober. While I'm intoxicated, I tend to take things a little too seriously and can get out of hand, and I very much apologize for that.
It's the third time you've done it. Maybe you should consider whether it is part of your character and you want to do something to change your character. But to say, well, it's not in my character when it's the third time you've done it, sort of empty words, don't you think?
And there it is. The judge calls him out point blank. "It's the third time you've done it," she says, cutting through every excuse he's tried to hide behind. This moment right here, it's the heart of the hearing. You can feel the frustration. Not just with one man, but with a cycle of violence that keeps repeating. It's harsh, yes, but it's honest. Do you think the judge was too tough or exactly right?
I mean, you've done it 3 times at least, right? You've been convicted 3 times. Is that true?
Yes, Your Honor.
Okay, so don't tell me it's not in your character. You do it 3 times, you're convicted 3 times. It's part of who you are. Change who you are.
Yes, Your Honor.
Ms. Goodrich, any recommendations from the people?
Yes, Your Honor. This plea agreement was done in consultation and approval of the victim who is present but does not wish to speak. I'd ask the court to follow the plea agreement and order 1 year in jail.
Mr. Frank, if I could send you to prison today, I certainly would. I'm not going to approve you for any program in the jail that would shorten your sentence even by 1 minute. If I see you again and I have a chance to send you to prison, I absolutely will. I'll sentence you to the maximum for the charge that you're pleading to, 1 year in the Sheboygan County Jail, credit for 142 days previously served. There's $50 in state costs, $75 in a crime victims assessment, $350 in court costs for $475. If you fail to make reasonable efforts to pay that by paying that when you're released, then you'd be subject to contempt of court. I kind of hope you don't pay it, so then I can give you 93 days contempt. So give me a reason to give you more jail and I'll be happy to. Otherwise, if you don't want to give me a reason, you want to pay that the day you get out. You understand me?
Yes, Your Honor.
All right, you can file an appeal if you wish by filing an application with the Court of Appeals. If you want a lawyer, I'll give you one, but you have to ask me within 6 months. We're going to give you a piece of paper explaining that appellate process and ask you to sign 1 copy or initial 1 copy. So we have a record we gave it to you, and the other one is filled.
The gavel drops, and James Frank gets 1 year in county jail, with the judge making it crystal clear. Any future appearance in her courtroom will land him straight in prison. It's a rare moment of raw accountability, showing that apologies mean nothing without change. Cases like this remind us, domestic violence doesn't just destroy relationships, it reshapes lives. If you found this case as shocking as we did, make sure to like, share, and subscribe for more intense courtroom breakdowns, and let us know in the comments. Did justice get served here, or should the judge have gone even harder?